So the next area or field that is falling under the very definition, scope, and jurisdiction of Article 16 is reservation. And in relation to reservation, we would like to discuss the very important leading case MC Bhalsala versus State of Kerala in 2006, and the very decision was delivered by the Kerala High Court in defining what exactly discrimination means as defined in light of the provisions of Article 16. So, as expressed by their lordship, children born to intercaste marriage of which either father or mother belong to scheduled caste or scheduled tribe category can claim reservation benefits only on proof that he is subjected to some handicap and disadvantages having been born as a member of scheduled caste and scheduled tribe. And now we'll go to the very provision relating to promotion. And in that field, we'll discuss the important leading case Jagdish Prasad versus State of Rajasthan, and it was a case of 2011 where the apex court expressed that the mode adopted by the state was violative of rules of selection and promotion by merit, where the rule provided for year-wise promotion and filling 50% of vacancies on merit basis, but the state did not hold examination for selection for many years and also made clothing vacancies of many years, as it was held in this important leading case, Jagdish Prasad versus State of Rajasthan in 2011 by our apex court. And now we'll go to another area where the very definition of Article 16 and its scope and jurisdiction was applied by our apex court, and that is relating to reservation and promotion. And in relation to that area, an important leading case is Ajit Singh versus State of Punjab, and it was a case of 1999 decided by our Supreme Court. So, where it was expressed that Article 16, Clause 4 and Article 16, Clause 4A do not confer any fundamental rights, nor do they impose any constitutional duties, but are only in the nature of enabling provisions vesting a discretion in the state to consider providing reservation for the circumstances mentioned in those articles so warranted. So, after this decision, now we'll go to appointment in reserved categories as it was defined in this very leading case, that is relating to P. Sudhakar Rao versus U. Govind Rao in 2013 by our apex court. And in this particular leading case, it was held that it would not be illegal to grant weightage to section of employees for the purpose of eligibility for appointment or promotion where it was not arbitrary nor violative of Article 16 and Article 14 of the Constitution as it was held in this leading case P. Sudhakar Rao versus U. Govind Rao in 2013. And now we'll go to another important leading case that is relating to very definition and scope of appointment in reserved category, and that is Union of India versus B. Dutt Majumdar in 2011 by the Supreme Court, where it was expressed that if no reason is recorded by the appointment committee, the refusal of appointment would be improper. So now we'll go to another important leading case, that is Bhupendranath Hazarika versus State of Assam in 2013. Supreme Court expressed that when there is a violation of the recruitment rules, the recruitment is unsustainable, whether any active part is played by a selectee or not has nothing to do with the appointment made a contravention of the rules as it was held in this leading case Bhupendranath Hazarika versus State of Assam. And now we'll go to another important leading case which also relates to the very definition and scope of appointment in reserved category, and that is Union of India versus Pritilata Nanda in 2010 by the Supreme Court, where it was held that the sponsorship for employment exchange is made essential, but such requirement cannot be construed as mandatory. So now we'll go to the very provision that Article 16 is an enabling provision as relating to the very decision of Nirav Kumar Dilip Bhai Makwana versus Gujarat Public Service Commission, where it was held that Article 16 is an enabling provision, and as Article 16, Clause 4 of the Constitution is an enabling provision empowering the state to make any provision or reservation of appointment or post in favor of any backward class of citizen which, in the opinion of the state government, to formulate is not, in the opinion of the state, is not adequately represented in the service under the state. It is purely a matter of discretion of the state government to formulate policy for concession, exemption, preference, or relaxation, either conditionally or unconditionally, in favor of the backward classes of citizens, the reservation being the enabling provision for manner and for extent to which reservation is provided has to be spelled out from the orders issued by the government. And now we'll discuss the very important Constitutional Amendment Act of 1995 and which particularly relates to promotion on the consequential basis of seniority, and it was dealing exactly to the scheduled caste and scheduled tribe. So, the very observations of this provision as made under the Constitutional Amendment 77 Constitutional Amendment Act of 1995, as it could be explained that the scheduled caste and scheduled tribes had been enjoying the facility of reservation in promotion since 1995. But before that, the position we would like to discuss the Supreme Court in its judgment dated 16th November 1992 in the case of Indra Sahani versus Union of India, which judgment was published in 1993. However, observe that reservation of appointments or posts under Article 16, Clause 4 of the Constitution is confined to the initial appointment and cannot extend to reservation in the matter of promotion. This ruling of the Supreme Court was considered to adversely affect the interest of the scheduled castes and scheduled tribes, since the representation of scheduled caste and scheduled tribes in services in the state had not reached the required level. It was thought necessary to continue the existing dispensation of providing reservation in promotion in the case of scheduled caste and scheduled tribes, and in view of its commitment to protect the interest of the scheduled caste and scheduled tribes, the government decided to continue the existing policy of reservation in promotion for the scheduled caste and the scheduled tribes, and to carry out this, it was necessary to amend Article 16 of the Constitution by inserting a new clause, that is Clause 4A, to provide for reservation in promotion for scheduled caste and scheduled tribes. The Constitution 77th Amendment Act 1995 seeks to achieve the aforesaid object, and as the very section that was inserted under this, the section 2 of this act inserted new clause, and that is clause 4A in Article 16 of the Constitution, empowering the state to make a provision for reservation in matters of promotion to any class or classes of posts in the services under the state in favor of the scheduled caste and scheduled tribes, which in the opinion of the state are not adequately represented in the services under the state, notwithstanding anything contrary in Article 16. And in regards to that, we would like to discuss some other safeguards which are provided under the Constitution of India to the scheduled caste and scheduled tribe population and to the social and economically backward classes, and such provisions are also defined, and their very scope and jurisdictions were decided also in a leading case by our apex court, and that is Comptroller and Auditor General versus Jagannathan in 1987 by the Supreme Court, and regarding those safeguards as it was expressed by the apex court on the question whether Article 16 Clause 4 is subject to any safeguard. It is relevant to point out that courts has insisted that it must be read with Article 335, which directs that taking into consideration the claim of members of the scheduled caste and scheduled tribes, the state should bear in mind that the claim should be consistent with the maintenance of efficiency of administration. This incidentally calls upon the judiciary to read together Article 16, Article 46, Article 335 as it was pronounced by the apex court in this very important leading case, Comptroller and Auditor General versus Jagannathan in 1987. So, after analyzing the very provisions of Article 16, as it provides equal opportunity in the field of public employment, and as we know, the public employment means those employments provided by state, and in the very provision of providing equal opportunity in the field of public employment, state could make provisions for reservation in regard to socially, educationally backward classes, also for scheduled caste and scheduled tribe population, and also those who are falling under the economically weaker sections. So also state could reserve the very class of post or classes of post for the scheduled caste and scheduled tribe population as per the Constitution 77 Amendment Act 1995, and the last important amendment, that was the 103rd Amendment of 2009, which provides reservation for economically weaker sections, and that up to 10% in those class or classes of post. And in this connection, it would be wise to call that this very article we could categorize under the head that it is relating to protective discrimination and public employment. So, to analyze this very article, Article 16 and its provisions, we found that the very reservation provided by state to bring a parity in public employment where they are not adequately represented, as it is the very feeling of state that those particularly belonging to the weaker sections of socially and educationally backward and scheduled caste, scheduled tribe, and even the weaker sections under economically backward, as it is the very feeling of state to provide reservation to bring a parity in public employment. It would be wise to call this very article as protective discrimination in public employment. So, in our upcoming video, we would like to discuss the very provisions relating to Article 17 and Article 18, while Article 17 deals with abolition of untouchability and Article 18 deals with abolition of all titles conferred during the Mughal periods and even by the Britishers to Indians, and that we'll discuss in our upcoming video.